Hello, good afternoon, everyone. I welcome you for the today's webinar, and it is on fast track merger. The intent of doing this webinar is completely to make the professionals and our colleagues aware about the integrities of every topic. So yeah, last in the last webinar we discussed on FLA. We discussed on the practical insight and how to do the filing of FLA. And it was, I believe, it has been a fruitful webinar. There were more than 100 participants at one time, and we had more than around 60 to 70 queries from the participant, and we tried to resolve it. Right. So similarly, on the same pace, we are expecting the encouragement and motivation from all of you. And today the topic is fast track merger. And to take this topic and to share the integrities on this topic, we have CS Varun Agarwalji with us. So I welcome Varunji, and thank you for sparing your time today and along sparing your time with us. And we are looking forward to a lot more insight and practical insight on this key topic, right? Fast track merger, because I believe in days to come, and the motive of the government is the ease of compliances. So when we talk about merger, yes, we all know how much time it is taking as on date, but yes, fast track merger in days to come will be a boon to us, right? And rest, looking forward an expert opinion from your end. So before handing over the dice to you, I just want to share a brief profile about Mr. Varun. Right, CS Varun Agarwal is a fellow member of ICSI, and he's a law graduate and a certified forensic auditor with overall 8 years of professional experience. He is graduated from Shamlal College, Delhi University. He has developed a strong professional practice in company law, insolvency, bankruptcy board, intellectual property right, income tax law, GST law, legal due diligence, secretarial audit, and merger and acquisition. His advisory experience also spans joint ventures, foreign collaboration, technology transfer, and capital market transactions. He regularly represents clients before regulatory bodies such as ROC, RD, NCLT, NCLAD, Income Tax Authority, GST authorities, and stock exchange, including NSE and BSE. He also handles matters involving FDI compliance, forensic audits, business structuring, and regulatory approvals from RBI, DGFT, FSCI, and other government authorities. He is currently heading his independent practice under the banner of Varun Agarwal and Associates, a peer-reviewed firm of company secretary based in Jeevan Vihar Building, Parliament Street, New Delhi. So, Varunji, we are looking forward to your valuable knowledge and your expertise on this topic. And we again welcome you and thank you for spending your time. And yes, thank you to all the participants, all the professionals, I must say, right, the corporate governance warriors who have spared time on this Friday afternoon to insightful interaction on this useful topic. So over to you, Varunji.
Thank you, Abhinavji, for the kind introduction. I'm honored to be speaking at this webinar on the fast track merger. And further on, I'm looking forward to sharing my practical insight, expertise, and all the intricacy of the fast track merger. Let's dive into the topic and explore the aspect of fast track merger, a crucial aspect, basically, we can say. So let's start with our PowerPoint presentation, and let's start with the straight away. Ritika?
Just in the meanwhile, the screen is getting uploaded with the PPT. I just request all the participants to keep posting your queries either in the on the chat box itself, and we'll take all your queries at the end of the session itself. And we'll also share the written answers to these queries to all the email IDs which are registered with us. Over to you, Varunji. Thank you.
Yes, thank you, Mr. Abhinavji. So start with the first slide is all about the fast track merger, and the merger include that one or two companies or more than two companies going to merge into single one companies. And traditionally, under the previous companies at 1956, we generally routed to the High Court to get the approval. And when we talks about the court approvals, it's take time, it's take intricacy. So the new concept come in the picture under the new companies that we can say Companies Act 2013, in which a new provision has been inculcated to 233, which talks about the fast track merger. And when we say the fast track merger, it is denoted with the power lie in the hands of the central government only. Because earlier, or we can say when we root through the NCLT, there is a practical hardship in any aspect. For example, if we start with the filing procedure in any merger, we can say, so merger start with the drafting of petitions, documents, and closure and everything. And when we talks about the traditional merger, we need to file in a specified format. And over the years, everyone experienced through the court merger that they are facing even in the initial stage of the merger. Why? Because there is some objection coming through the listing procedure. Sometime it will take 1 month or 2 months time to get it listed on the NCLT. So that's why the concept of faster merger can be used as full. But fast track merger is not available to all the companies. Fast track merger can be available by the class of companies. It is not available as compared to the 232 of the Companies Act read with 230, which is the provision applicable for all companies. For example, if we talk about the court merger are available to every company, whether the company is solvent or not, whether the company is being falling under the particular class or not. But when we talk about the fast track merger come with the class of company. Currently, the effective class of companies, there is a 4 class only. Recently, a draft rules also came into picture, which is get published in the month of April onwards, on which the comments has been invited, and the remaining classes till the date is not been effective. So when we talk about the eligibility condition straight away for the fast track merger, it comes with the first of all that the company should be a small company. The companies involved in this merger being a transferee company, or always be a small company. First of all, the second category belong to the holding and the wholly owned subsidiary company. The word is wholly owned, not the subsidiary. And the third class is the 2 or more startup company, you can say it. So, and the one more is class is there as per the rule 25 of the compromise arrangement rules, which is the one is small company and the other one is a startup company. There is another 3 class has been notified by the rules, which is widening the scope of fast track merger by the rules, and which is also the class is one class pertaining to one class is that one or more unlisted company with one or more other unlisted company having a borrowing limit, borrowing facility below 50 crore on the event date, and no default is there, can be eligible to come under the scope of fast track merger. The second category is holding company and the subsidiary, unlisted subsidiary, which is a much demanded rights, because sometimes what happen if we adopt to fast track merger, then we need to have a wholly owned subsidiary company only. Now the rules has been there. Once it get effective, then we can explore the possibility of common practice. The holding company can merge its unlisted subsidiary company through the fast track merger only. And the last class is one or more subsidiary having another subsidiary, and both the subsidiary having a same holding company, and we technically called as fellow subsidiary. So these are the 3 classes which is yet to be effective, but once made it effective, it will be blessings for all of us not to approach the NCLT, and it will reduce the burden of NCLT as well. So basically it start with there. And now before commencing going further on the procedural aspect, fast track merger come with one more technicality, which you can say a technical right, a solvent company. In fast track merger, one of the criteria is there that you should be a solvent company. If, for example, is your net worth is going to be negative on a moment, then you are not eligible, because in the fast track merger you need to give a certificate through auditor that both the company or more than 2 company, all companies should be insolvent. So sorry, should be a solvent company by filing a declaration of solvency. So let's move further on. This is the criteria which is I've already included, which is yet to be effective for one of the class, in which the borrowing of the companies involved in the merger should remain less than 50 crore rupees, and the company should not be defaulted in repayment of such borrowing till the moment we are proceeding with the fast track merger. Further on the next slide, we are generally through this slide covering the authority to be involved in this. The basically on the first motion we usually call through for the first stage of the merger generally involve the ROC, OL, and the income tax on the first motion. In the later part, the Honorable Regional Director by having a delegation of power through central government came into picture. So in the first motion, which generally talks about the having a in principle approval through the board resolution, and before going past having a board meeting or having the board approval, we need to prepare certain documents for having go through the merger. Like we have to have a draft scheme in place. In the scheme as well, there is a some minimum content should be there. For example, appointed date should be there. Well, share exchange ratio should be there in the scheme, because scheme is a very crucial part of any merger, whether it be related to NCLT, whether it be related to fast track merger. Minimum content or from the practical insight should be there. Otherwise, later on, you will receive the objection in the scheme that this is not there and you need to revise it. So minimum content like the appointed date should be there, effective date should be defined in the scheme as well. Income tax provision, which enumerated that your all assets liabilities should be transferred to the transferee, including everything, and no shareholder of the transfer company will receive in cash anything if you want to avail any benefit from the income tax provision. So it should be there in your scheme. Also, scheme should contain the merging of authorized capital. Scheme should also contain the waiving clause, severability clause. In case future, if you receive any objection, your director can be authorized to do the same. Further on, please move on the next screen. Next slide. Now, further we can discuss about the fast track merger benefit. Why it will be benefit? Why will not go for the NCLT? There is some 3-4 significant differences, right? There is a in through the whole process of the fast track merger, there is no need of public advertisement, which is required in the second motion in the NCLT. This is a big relief. It will save the time, it will save the cost of the applicant involved in this merger. Further on, for example, if we talk about the court approval, court can only grant the approval when the matter get listed or even when the matter get the time. Sometime in the NCLT merger, your matter is listed in the, you will get the fruitful date, but on the date itself, the time, the matter has not been come and the bench has been left alone, and you will get the paucity of time order. So it will sometime take 1 year or even 2 years for getting the first motion itself. So in fast track merger, there is no such kind of any regulatory approval required till the date you have filing the application with the central government. So this is the one of the major benefit, that you can move through the executive process, not a court appointed process, or you can say a court called process. Another one is the faster. Why we are called the fast track? This is the fast track merger, as I already enumerated, that the court will, for example, if we need any direction, if we need any approvals, we need to have a date in the court process. In fast track, till the matter file with the regional director, you do not need to wait any date, official date. You need to go through the process, first motion, second motion. That's why it will take, it will called as fast track merger, not as a normal merger governed by the section 230, 232. That's why the all mention benefit, no mandatory approval required from NCLT, no need of public notice, no need of issuing public notice, less procedural complexity, faster than traditional merger, and less administrative burden and less cost and time saving. Moving on further to next slide. It's been all about the small company definition. Everybody is aware about the right now the governing provision of small company definition, that is the effective paid up capital up to 4 crore and the turnover remains should be 40 crore under the umbrella. Then the that company should be called a small company, and that small company can take the benefit of fast track merger. But a small company definition include holding company, section 8 company, public company, and company governed by the special acts. So this is the general definition about the small company. Moving on further, there is another category that is a startup. Everybody knows the which company called as a startup. There is a time period of up to maximum 10-year vintage, less than you can say 10-year vintage for recognized as startup companies. Turnover cap should be there for 100 CR. You cannot cross in any financial for more than 100 crore, and you should have a certificate before approving the scheme, before initiating any fast track merger, if you classified yourself that the both companies mean the startup company. So this is journal talks about the startup, how which is startup, which is not. Moving on further, this is all about the holding company. There is a one technical point in this. I have seen in many of the past cases, there is a concept of step down subsidiary. Generally, the subsidiary definition only include direct relationship. That is the holding company, and the holding company directly hold more than 50% share in your subsidiary company. That relation recognized by every regional director across the region. And sometime the petition has been filed saying that the fellow subsidiary merging with the another fellow subsidiary, it is falling under the definition of that section. And from my practical experience, no authority yet the movement has approved this kind of merger. In this kind of, for example, if you go for the fellow subsidiary, which is one level below the original subsidiary, in that case, the honorable regional director will straight away refer your matter to the NCLT, that this particular class is not falling under our umbrella. Now you can you can govern the process, or you can direct the things in this merger. So this is a very technical point, that if you coming with the wholly owned subsidiary criteria with the holding company, it should be direct one, not the indirect one. And one more point I'm discussing right now with the in the previous slide, when we talks about the merger between the wholly owned subsidiary between the and the holding company. In that case, you will get one more added advantage, that you will not require any valuation report, because the all shares held by the holding company will get cancelled post merger. So there is a no issue of any single shares in the fast track merger. That's why the authority will not demand from you, or even if they demand it through the notice that please explain where is the swap exchange ratio, so you can simply reply by saying that this is the merger is going between the holding company and the wholly owned subsidiary company. Post merger, there is a no single share will be issued in lieu of any consideration. That's why we have not taken the valuation report of both of the company. Moving on further, this is a journal procedure in the short form, that before merger you should check your AOA, you should check your MOA. In terms of MOA, there is a two technical point is there. One is related to MOA, that your transferee company object should cover the object of transferor company. In most of the cases, every authority asks about a particular clause, that how your transferee company object will cover the object of transferor company. If it is not going to be covered, they straight away give you the instruction that you first amend your MOA to widen the scope of your objects to include the object of transfer company, and then come with us for the approval of fast track merger. One point, and another point is the enabling clause in the MOA. MOA should contain a provision like that this company can be merged with the another company for the benefit of synergy, etc. and etc. So there should be two clauses in the MOA required before going into merger. If it is not there, you can amend it or align with the procedural aspect. Second one, if you have finally decided that now the document is there, everything is there, go for the board meeting. Board in principle approval of the board required before filing any single paper with the authority. Once you have the board approval in your place, then you need to invite the comments from the ROC, from the income tax, from the OL, official liquidator. These three authorities straight away indulge in the first process. And when we are saying about the after board approval, we are going to send the notice inviting objection and comments, and the notice should be sent in a format called as CAA9, which is a specified format given under the compromise arrangement rules. And along with that, you need to attach some more document, which we will discuss later on the screen. Now coming back to the this slide only, Ritika, keep it on this slide. I'm just enumerating in a crisp form. Further on, once you submit that notice inviting comments, waiting for the statutory period, go for your class creditor approval. For example, in your company, if there is a multiple class like FC, financial creditor, operational creditor, and there is some other class, then you need to take multiple approval by the meeting, or if your creditor is ready to give in writing, then by writing is also allowed in the fast track merger. Further on, getting your class shareholder approval. The general meeting is there, but the technical word is called the class shareholder approval. For example, in your company, if there is a multiple class involving in the equity itself, in the preference as well, then you have the separate approval for every class. Based on that, you need to file once your scheme get approved through a requisite approval, which we'll discuss in the next slide. You need to submit all the paper related to your meeting, as well as the previous paper, notice inviting objects, scheme, and etc. with the central government, which is the central government is right now has delegated its power to the regional director. So you need to submit through the e-form all the paper to the regional director, and as well as to the ROC, income tax, and OL. And once the comments has been received, once the objection has been received, and you have clarified through the reply, because generally what happened right now, there is a two stage in which you will invite a comments from the authority. But from the practical experience, recently all the ROC somewhere decided that on the pre-approval of class meeting of the scheme, they will not issue any objection comments. Even they will not send a single questionnaire, basically demanding the certain information related to fast track merger. Later on, once you get the your shareholder approval and creditor approval, then they will issue the separate questionnaire. For example, OL will issue the checklist to the transfer company. RD, Honorable RD, ROC will issue to the transferee company. So you need to reply again. And once the everything sorted, everything given the green approval, then on the basis of that, the central government will pronounce the order in that case. Even in some of the cases, the regional director will not even assign a single hearing. If the papers are fine, everything is in place, there is a no any gray area in the company, there is no any qualification objection report by the auditor, and once you based on that, they will RD will pronounce the order. And once you receive the order, you need to file again as similar to the NCLT INC 28, and this is the whole process. Now one by one through the slide, we will discuss the more intricacy on the every step we need to take in the faster process. Ritika, please move on the next slide. Now I have discussed already check about due diligence about your MOA. I have already discussed the 2 points. One is on the slide, one is related to your main object. The other point is talks about the due diligence, why we require the DD. Because what happened, once you receive the questionnaire from the any authority, they generally talks about required a 40.28 30-point questionnaire, and that questionnaire include about your every compliance applicable on annual basis or event basis. For example, one of the case, for example, if you are claiming that your applicant company holding and wholly owned subsidiary, in that case they will ask the copy of MJT 456, which is required to made a wholly owned subsidiary company by giving the beneficial declaration section under section 89. So based on that, they will ask about the last 5-year transaction related to related party, your auditor qualification remarks, your reply, your statutory pending dues, your any and the e-form applicable across the Companies Act. So generally they will ask about everything. And if you done the due diligence before going into merger, for example, not for 5 year, even you have done the 3 year, so you go through the everything. If anything found that is not compliant in last 3 year, then before going into merger, you can go for the adjudication of penalty to make the default good, or if the compounding is still applicable, then go for the compounding. I'll tell you one more experience from my past cases, that in one of the case, the client has sometime the client came with us the part assignment of the fast track merger. They will say that DD has been done, now you can move on further to the procedural part. And what happened in that case, the AOC 4 from the last 3 year file is not complete enough. So ROC Delhi has straight away given the notice that first you rectified your AOC for MGT 7 complete, go for the rectification, go for the adjudication or compounding, whichever is applicable. And once you made the good the default, then come with us in the first motion itself. So this is the why we need a DD before going into fast track merger. Everything should be covered. Like there is a Excel checklist you can prepare, or even you can prepare in two different. One is related to the annual compliances base, which is applicable straight away, and one is related to the event base. For example, if band 2, a very crucial concept, recently every authority ask about the if there is any corporate that have whether you have filed the band 2 or not, or for example whether you have filed the appointment auditor form or not. These are the simple aspect which you need to look. Apart from it, you need to go through certain other things based on your balance sheet for last 3 years and 5 years. That's why the I generally call the DD is required before going any fast track merger, or even for the merger as well. If the client permit you, and if the client is not permitting you, you can give a disclaimer that later on, if anything came across like that, then the client itself is responsible for it. We will not. Moving on further, Ritika, go to the next slide. Yes, valuation report. This is a respect earlier we will take the valuation report from the having a specified experience from the chartered accountant, and we in the 1956 act, like in post 2017 the section 247 came into picture, which made effective, and the new concept is come the registered valuer. And across the companies act, I'm saying not under the section 233, I'm saying across the companies act, if you take the valuation under the provision of any companies act, then you need to take from the RV only itself. No other professional even is allowed as per my knowledge. If anything found contrary to it, we can go through, but the provision I have read in my practical journey, the RV valuation report is required for this merger or other aspect. One point is there that where the valuation report is not required, I already discussed that the holding company and a wholly owned subsidiary right now, no valuation report is required, as the reason is itself explanatory that the no post merger there is a no issuance of any single shares, there is a no allotment of any kind of shares. And the related to it further, I'm repeating again, whenever you go through your scheme, if the wholly owned subsidiary or holding company is not going to be involved, they'll almost check that whether the swap ratio is mentioned, because sometimes what happen, we are presuming that the valuation report is there in the petition itself, in the document everywhere it's mentioned, but exact line, for example, if in the valuation report the conclusion is written that for every 100 share you will get a 800 share of your transfer company, that line should be written in your scheme as well. Otherwise they will issue a notice that your scheme is being defective, swap ratio is not mentioned in your scheme. So swap ratio is very much crucial if the holding and wholly owned subsidiary in fast track merger is not involved. The other topic mentioned on the slide, that the object clause I have already discussed, should check comprehensively main object. Sometime, for example, client is saying that both company involved in the IT chain, IT objects, IT software, even then also you must check that whether the complete is included or not. If later on that on the technical basis it is found that your transferee company is not going to be include the main object, then you will face the difficulties, and you need to again come with the passing the resolution, getting the shareholder approval for the main object amendment as well. Moving on further, now this is the procedural aspect, all about the board meeting approval. In principle, in the board meeting itself you need to identify the agenda to be discussed. For example, approval of draft scheme of arrangement, approval of declaration of solvency of both the companies. Both the company, you can say separately, means transfer company will approve their solvency, and transfer company itself respectively, both the companies separately in their board meeting will approve the solvency. And in solvency generally there is a specified format, you need to put the book value and the market value of the asset side and the liability side. After that you need to have a either zero balance or surplus balance. So that's on the basis of that you will be declared, your company will be declared as solvent company. Based on that, your auditor will give the certificate that the company is being, both the company involved in the merger is being the solvent company. One more item is there, that the share entitlement rate, that you need to take a valuation report, and valuation report should not be older than 30 days. For example, if I'm going to convene a board meeting for my fast track merger on 1st of July itself, then the valuation report should be obtained not or before 1st of June. Means the board meeting date, from the board meeting date, your valuation report should not be older than 30 days. Otherwise, they will raise the objection from any authority like ROC, RD, or OL somewhere. Other things, that the journal, that you need to empower your directors. If director only there, if company secretary there, then you need to authorize the company secretary as well to take the action for the whole process. And as well as you need to give one more authorization to your practicing professional to appear on behalf of you, to liaison with the authority on behalf of you, or to file the reply on behalf of you. So this is a major aspect of the, you can say, your first board meeting. Move on further. And now once you held the board meeting for both the company or even all companies, then first action lie in your hand. Then you need to send a CA9. That is a prescribed format. Nothing is journal format in which the comments has been invited from all the authority, income tax, ROC, OL. This is a physical form. You need to serve through the speed post or registered AD. And there is some attachment to it, CA9. That is your scheme copy, your shareholding pattern, last 3-year audited financial statement. The last 3-year audited financial statement has been recommended, nowhere mentioned in the CA9. And you need to give the memorandum and article copies, board resolution, and the valuation report, if any. For example, if related to holding and wholly owned subsidiary, then valuation report is not required again. And once you file the CA9, and one more topic is to be clubbed with the CA9, that sometime in the provision, nobody get, even sometime on the plain reading, there is some ambiguity that CA9 to be served separately, CA10 to be served separately. It is not. In practical sense, you need to prepare both CA9, CA10, and to be served CA9, CA10 complete all together with the speed post, RDAD, and through the GNL2 as well. In the GNL2, you need to file declaration solvency, which is CA10, and with the CA9 as well. Because generally the authority look over the complete bunch, not the separate individual document itself. So CA9, that is a notice inviting the objection or comments, and CA10, which is a solvency certificate, you can say, which again need to be filed in the GNL2 with the as an attachment CA9. And once you file the GNL2 and you have served physical copy as well to all authority, you need to wait for 30 days statutory period. In that period, you will not allowed to hold your class meeting for taking the approval for the second stage. You need to wait 30 days. You can do license, but if you license within 30 days, generally authorities say from the practical experience that wait for the 30 days. In 30 days, they will not going to issue any notice. Once the 30 days over, you need to take a, you can say through the licensing official, you can verbal communication, because in that case also they will not serve a copy. Even they have the NOC, they will serve the any nil comments to the RD if they issue. But in practical sense, right now, no authority is issuing any objection comments in this stage. They say come with the CA11 later stage. So once the 30 days period is over, do not wait for more than another some few days. Prepare to start for serving the notice for another stage. Now, moving on the next slide, I'm just giving the prescribed format, which I am already discussed with you, that is the CA9. This is a journal standard format prescribed by the merger rule, amalgamation merger rule, which is clearly talks about that the notice is when invited by the transferee company to all the stakeholder. Whosoever be interested will send their comments. So this is the journal format. You can download from the annexer attached with the rules. This is the CA9 standard format. and this will be used as it is. There is no some any modification required. Generally there is some basic detail required from the company name and etc, nothing more than there is no requirement to further amend to make it 1 page, 2 page, or 3 4 further on. So this is a general format, and you need to fill basic detail and attach the attachment with it, and just need to send through the speed post or RDAD. Moving on further, next slide. That is which I'm talking about, that is the declaration of solvency, CAA 10, and it is required by both the company, and it should be delivered or filed through the CA9. So CA9 and CA10 is being the collective document. I'm not treating as the separate document. It will go as a complete bunch of the file. So CA10 will be filed in the GNL2, and it should be filed by both the company, transferee and transferor, separately. And when we look around the attachment, the same attachment, but there is some requirement is there that the statement of assets and liability should be there, and which is on the latest date, your values, not the last audited one. The auditor's certificate with that required for the accounting treatment of merger, and the other attachment is the journal BR and the other certificates only. One more point, that this solvency certificate in Delhi NCR should be required on 100 rupees stamp paper with notarized and witness as well, and should be signed by the two director. And if the managing director is there on the board, then the sign should be that solvency certificate should be signed by the managing director as well. So this is the talks about the declaration solvency. Moving on further, now it's a simple process that if the objection come, if the objection is not come, if objection come, then you need to again modify the scheme, if and conduct the board meeting, then amend the draft scheme, then fix the date time, then again serve again. If anything is required, then you need to serve again to the ROC. If it is not required in the ROC comment, then you go straight away with the class meeting of creditor or the shareholder. Moving on further, now the content of CA10 is mentioned over the screen, and it's being the standard format given by the rules, amalgamation merger rule, which is the CA10. This is also a physical form. It is not a e-form, and in which the company detail, everything has been there, and basic detail listing or non-listed everything. And in that declaration of solvency, it is written that we have made in the inquiry affairs of the company, etc., and made an opinion that the company will remain the solvent throughout the 1 year, within a period of 1 year, you can say. Even this solvency certificate, you can relate to the winding up, voluntary winding up under the Companies Act, erstwhile Companies Act, which is 1956. Right now, the company's voluntary winding up going on under the IBC as well. This is the same as it is applicable in the voluntary winding up cases as well, that the company should remain liable. Moving on further part of the same form, go to the next slide. This is the part of CA10 as well, in which the two director signature is required, and the attachment is mentioned, then the copy of board resolution, statement of asset liability, and the auditor report on that. And below that, the annexer is there. If you are if the screen is visible to you, all the book value need to be mentioned, or realizable value also to be there. So there is a two value in there. So one is asset side, and below that, move on the next slide. This is the liability side. Now, once you determine everything, to get the estimated surplus value. For example, if in the last there is a negative surplus coming, that mean that your company is not a solvent company. In that case, your company is coming out from the preview of fast track merger. So this point should always be checked before going for the merger, because for that, in that CA10 need to be certified auditor as well. So if the negative is there, that you will not mention in the CA10 that your company is solvent. So this is the complete prescribed format of CA10, which is given by the rule. Moving on further, notice of the meeting, and is being the same notice, as you can say, matching with the NCLT govern meeting, almost the same, you can say. The attachment are same. In that, if the NCLT giving the direction to conduct a meeting in which there is some other clauses are there, but 80% 90% are the same. You need to prepare a notice. And now one more clarification is there. There is a practical question arises whether we can do the meeting on shorter notice. It is absolutely allowed in the provision of the act. You can have the consent of 95%, or you can say even 100% as per the act. And once you receive the class consent that you can have the shorter meeting. So for example, if the 30 days is being over, based on that, you will arrange a meeting in 7 days, 3 days, based on your convenience of your shareholder or creditor. But make sure that this date should be aligned with your creditor as well. For example, in your company, there is a class of unsecured creditor, there is a class of secured creditor. So the provision is like that, once you get the approval of creditor and shareholder, you have ultimate 7 days from the date of approval itself. For example, if you say that your shareholder is going to be approved in 7 days after 30 days period expire, and your creditor takes time, then it will take some gray area, because in the act clarification it's not there. So I must recommend that I have reused in my practical cases that whenever you are going for the meeting or approval process, you should align your shareholder approval date with your creditor date. So first of all, shareholder is your promoter. Most of the cases the shareholder is being your promoter. Always arrange in writing approval from the creditor. If creditor ready to give in 10 days, so you can have a class meeting and you will serve a notice to the creditor to approve in writing. And for example, if the specified value of the creditor or the for example, for the member, you do not have any criteria to get it approved in writing by consent. For shareholder, you need to arrange a meeting, you need to call a meeting as per the formal procedure. But for the creditor, there is a liberty allowed similar to the NCLT, that if your creditor is ready to give the consent, then you can have the consent. if if the value meet it, for example, later on we will discuss about the how much percentage is required for both the classes, for example, shareholder and creditor. If that case, if the consent is equivalent to same, then you can take the consent in writing. If not the same, then you can have the member meeting separately, creditor meeting separately with the same date. For example, if you are going to plan a meeting for the 1st of July for the shareholder, then you can arrange a meeting of your class in the morning. On the same day evening, you can call your creditors. And once the meeting is over, then you have ultimate 7 days from there itself. You need to file to the honorable central government, that is the regional director. You need to file the copy of all the papers with the OL, ROC, income tax. So ultimate 7 days is being there. So you need to act in advance prior to completion of 30 days. So you can have a draft, you can say, ready to send the notice, ready to take a dates from your shareholder or creditor. So everything should be placed, because 7 days will not going to be extended in any practical difficulties. Authority straight away decline the case that you have time bar, you have not filed within the 7 days. So these are the now I'm coming on the formalities that if you are going to send the notice of the meeting, then there should be attachment to the notice. One is the CA9 CA10. CA9 CA10 will be there, everything. Whenever you file CA9 CA10, post that, you need to again attach the copy with the notice. And your scheme part, your other document which is attached with the CA9 CA10, like board solution, valuation report, accounting certificate. And one more thing is there, with the notice in the explanatory statement, there need to be attached a statement generally governed by the rule 6 of the compromise arrangement rules. And through that rule, the rule is talks about the journal information. For example, all the detail about how the approval has been taken for transfer or transferee, and the interest of the KMP in this scheme, whether the promoter interest is there in any way, your other stakeholder director interest is there or not, like conflicting interest. So this is the 15-16 pointer is there in rule 6, you can say. And you need to attach that statement as well with the notice of the meeting. Or if notice is not going, if you are taking the NOC of the creditor, then in that case also you need to send the statement as well under rule 6. It is mandated under section 233 that whenever you have the notice, you need to fix that statement as well. Moving further, next slide. Now the approval is now we talks about in this slide the percentage we required for the approval, and it is for the shareholder approval we require 90% of the total number of shares. I'm not talking about the present and voting. Generally in the class meeting we generally says that for example in the NCLT it's been clear that present and voting is counted, not the total paid up capital as on date, but in the fast track merger total number of shares. There is a no criteria of those who are absent, those who are participated but invalidate the vote. There is an absolute crystal criteria. If the paid up capital is 1 lakh, shares is 10,000, then you need to have a 9,000 shares in your favor. Through that, your scheme is going to be approved. And similar to the same, there is a one more adding criteria, that is in the case of creditor. In the creditor, the criteria is simple, 9/10 in value, but majority is required. It means numbers in person is required. For example, there is a 10 creditor and you have the one creditor holding the total value of 9/10 he has given, but other than that nobody has provided you the consent, then the approval is not there. You need to have in numbers the 6% is there and the value is 9/10 of the total outstanding debt. And these all are the approval required class wise. This is not a general meeting. If you describe in your article in your shareholder agreement there is a multiple class, if you have the cap table, then you need to take separate class approval for every class. In the similar manner, creditor for the same. For example, if you have the FC, financial creditor, debentures, and the operational creditor, you need a separate class approval as well. And once you get the approval in the meetings of both the stakeholder, then you need to file the MGT 14. Generally the requirement to file the MGT 14 is not arises in throughout the provision of Companies Act 233, but it's coming coming out of the preview of 117, which is a general section for passing the SR for anything. So generally MGT 14 required under 117 only within 30 days. MGT 14 you can file 30 days, but technically you cannot file after 7 days because you need to attach the copy of the MGT 14 and etc. with your RD application as well. So MGT 14 is required to be filed. Moving on, the MGT 14 content is being there, copy of the resolution, notice and explanatory statement, consent of shorter notice. And one more thing, you can attach the proceeding of the class meeting or creditor, etc. and etc. And one more, coming on the next slide, yes, on the next slide. The next slides I have already discussed. The requirement to file everything is 7 days for physical, for even you can e-form. For example, CA 11 is the requirement which is prepared by the chairman of the meeting, and along with the other attachment you need to serve the RD1 which is a e-form, and CA 11 is the physical form, physical report of the meeting. So you need to file electronically, then physically, and the same copy to the ROC and OL. And one more form is requirement. There is a GNN1 which is to be filed with the ROC only by the both company for the safer version. Although section 233 talks about that you post approval of class meeting you need to file through the transferee company only, but I am recommending it to you that file the GNL for both of the company. RD1 shall be filed by only the transferee company with the attachment of CA 11, but GNM1 is being filed by both the company. And if we are talking about the physical delivery of this set, so in that case you can file a complete petition having both the meeting approval detail of the transferor or transferee. And generally when you going to file the CA 11, it will include the details of the transferor and transferee. So it will going to be through the authority in physical sense through the complete set, not individually. For example, transferor is sending separately, transferee is sending separately. But if the case pertaining to the companies which is not situated in the same state, for example, transferor is situated in Delhi and the transferee is situated in the Bangalore, then the RD1 will be filed by the only transferee company, but the physical set to the ROC, to the RD, or you can say income tax, or OL, you need to serve separately, except for to the RD, transferee company will only require to file, either be physical copy or e-form. So this is the filing procedure post approval of class meeting. And the GNL1 attachment has been narrated in the slide, that the provisional balance sheet even you can have at the time of board meeting itself. It is not required further on to get the balances. On the board meeting, first motion board meeting before the CA9, you have the provisional balance sheet in your, or you had a limited report by the auditor over there, and the other document like CA9, CA10, and the, for example, you have the minutes of your class meeting or creditors proceeding of the meeting, CA11, and the other incidental attachment, which is already there in your hands. So it should be attached in the GNL1 as well, or form CA11 as well. Moving on further, on the next slide, Ritika, moving on. Next slide will talk about standard format given by the amalgamation rules, that is the CA11. That is a report prepared by the transferee company, presiding by the chairman. So it will all include the detail related to your criteria. For example, third point talks about small company or holding and wholly owned subsidiary. So CA11 will straight away give the identification to the authority that this merger is coming for the small companies in between, or the holding and the wholly owned subsidiary company. The fourth point is about the general basic detail. The other, for example, sixth point will talks about the approval dates, notices, dispatch date, everything, because they will ask, once they issue the questionnaire, every proof you have served. It will not be by hand. It should always, for example, if you have the class meeting, if you have the creditor meeting, you should always have a speed post receive or RDAD or email proof or any other legal recognized proof for sending the all the proceedings documents. Later on, moving further, this is the detail required by the approval of member. For example, in this slide, if you taken the creditor approval in writing, then you can give the explanation, because you don't have any meeting date of the creditor. So you can put the in text that meeting has not been held. It been approved through in writing only. So an NOC, no objection certificate, has been attached through it only. Moving on further, this is also a declaration who will give the CA11 that the notice has been served, that the every procedure to the date, on the moment when we are going to file the CA11, has been complied with it. So it's been the general declaration for compliance purposes. And the attachment has been mentioned, copy of the scheme of both the copy of the scheme approved by the both creditor and the member, notice sent in accordance with 233 and rule 6 statement, and the optional attachment. Generally the format prescribed the minimum documentation, and because why they have prescribed the minimum documentation, every authority will send you the notice. In the notice there is a questionnaire attached, and the questionnaire contain questions of 35, 40, 28, depending on the different respective authority. But every authority will ask you through the questionnaire that you need to provide everything for last 3 years or 5 years. That's why at the time of CA11 filing, they will not require much document. But as a matter of concern, or you can precautionary step, you can give an additional document. But even though they will require a separate complete list, so it's up to you in the practical sense. Generally, it's been suggested minimum documentation should be there. Some 2-3 more documents should be there. Apart from it, do not give right now. Once they send you the checklist, once they send you the questionnaire on the practical sense, then you need to reply accordingly with the complete answer. This is the way. Now moving on further. This is the step 6 submission of report by ROC and OL to the ROT, to the RD. Basically what happened, I already explained the things, that objection will come. Objection come how? That first of all, the authority will ask you the questionnaire. You will reply it. Later on, they will again come if they have any objection. So objection, or you can say comments, they will clarify from yourself. For example, in some point now they determine that you are not able to address the query raised by in the query letter. Then in that moment, they will send the final report to the honorable regional director, putting the comments that the company has not addressed. And that way, our honorable regional director will adjudicate the matter on the merits by listening to your version, the other authority submissions. And if central government feel that the matter is not reviewing, not favorable in the public interest or to the creditor interest, then they will either refer it to the NCLT or may pass the any other order, whatever they feel right or whatever the authority feel rights for it. And once the in that process, even the regional director will provide the one more opportunity to the company that please clear out the query raised by the OL or ROC or income tax through the affidavit and everything. And once the central government gets satisfied, that is the regional director, then they will straight away pronounce the order. Even they will, in some of the average cases, they will not send a single notice to you that please present on the particular date as being the hearing called. So generally they pronounce it. That's why the fast track merger completed on that moment. And moving on further, this is the which I have already discussed with you, where the scheme is in the public interest or not. If the ROC will have no objection, then RD will give you the confirmation order. If it is not, then RD have the option, honorable RD has the option. They either way suggest or will file the same to the NCLT to adjudicate the matter. And as far as the provision is concerned, it's been talks about the 60 days for the central government to decide the matter, either file the application or approve the scheme. So if, for example, if the matter goes to the NCLT, NCLT may give the direction either for the fresh procedure in this case, or take up the matter on the merits, that if the everything is there, the applicant has convinced the court there has been no prejudicial interest being affected of any stakeholder, that there may be chances that NCLT will approve your scheme. And that way the matter will be covered through the provision of 230 232, not with 233. If the central government transfer your matter or file the application in CA 13 to the NCLT. Now coming back to the positive side, if you satisfy most of the fast track merger has been convinced by the central government, there is no such intricacies involved. In that case, the honorable RD will pronounce the order, will confirm the order, and once you receive the order in CA 12, you need to file it with the INC 28 within 30 days. And in INC 28, you need to check whether the authorized capital is increasing or not. If it is increases, then you need to arrange a challan of stamp duty paid by the transfer company, because as per the provision, you will get the set off of the stamp duty payment paid by the transfer company. So you need to have a letter. In the letter, you need to have a tabulated form through explanation. This is the X capital of my transferee company. This is the X capital of transfer company. Post merger become this much, and for that capital, the transfer company has paid this much stamp duty. And if any deficit found, you need to pay stamp duty as well in the INC 28. Before 28, you need to generate a miscellaneous stamp duty challan. We need to attach in INC 20 as well. So this is the complete. On that moment, your merger get completed. Post merger implications are also there, which we will discuss later on. Moving further, CA 12. This is the standard format. This is the order format. Basically, the honorable RD will pronounce in this format only the confirmation of the amalgamation scheme. Now on the next slide, this is the CA 13. It is not our related document because it's been used by the central government. If the central government feels that it matter should be adjudicated by NCLT only, they will, and the central government feels that the matter has been against the public interest or the stakeholder or the creditor, So this is the general standard format been recommended to the authority to use it to refer to the NCLT. Moving on, next slide. This is all about the effect of registration of scheme. And you know that if the once the merger approved, the transfer company going to be dissolved or wind up before without following any winding up procedure. Once your INC 28, and one more thing, INC 28 filed by both company involved or all the company involved in the in this merger. So once your all the INC 28 get approved, your master data status of that transfer company involved get amalgamated, and the sin of that company will be deactivated on the moment. So this will include transfer of all assets and liability from the income tax point of view as well, transfer of all legal proceedings, transfer of all legal certificate, all debts, all liens, and etc., even the employee as well. So all the, for example, business is going to be transferred in a bunch or in a complete set. So all the thing which is lie in the balance sheet of transferor company will get merged in the balance sheet in terms of value, in terms of non-monetary like contracts, employees, non-monetary things as well. So this has been the effect of registration of it. For example, in that scenario also, if the land is there, for example, there is a two assets in the class. One is movable, another one is immovable. Movable generally transfer by possession. Immovable is being transferred by the title deed. And for transferring the title deed in the transferee name, for that you need to approach your sub-registrar office of the respective state in where the sale deed is going to be registered. For that getting the title in the name of transferee company, you need to pay the stamp duty on that immovable property. So generally we are sometimes get confused that how on which points we required to pay stamp duty. For example, your authorized capital is going to be increased, you need to pay stamp duty of differences amount. One thing is there. Another one, if you issue any post merger any share allotment, then you need to get the share certificate. If it is in physical mode, you need to pay the stamp duty on the physical share certificate. For example, if you have the land, it is going to be changed in the company name. Again, for getting the title deed transfer in the transferee company name, you need to pay stamp duty according to the State Stamp Act. Some State Stamp Act provides some relaxation somewhere, like for example, sale for generally sale deed registration providing a 6 to 7% stamp duty with the registration charges as well. In some cases, a relaxation is there. In the merger cases, 3% or 2.5% or 1.5% for that registration is required. So you need to adapt that thing accordingly. This is the effect of registration of the scheme. Even one more point is there. I'm telling from the income tax point of view. For example, if your INC 28 get approved and you have filed the ITR before the year 28 approved for the last previous financial year. For example, I'm taking a hypothetical example. In the scheme, your merger date is 1st of April 2024, and your merger get approved in the month of July. And before going to file the merger INC 28 with the authority, you have filed the ITR before that separately for both company. Now what happened, as per the income tax act provision section 170A, it talks about the 6 months time period that once your order get registered, you need to file the revised ITR by taking the balances of transfer company as well. So it's been the requirement of income tax act that the successor company required to file the revised return by taking the asset and liability and the, you can say, balance sheets figures into your balance sheet, a revised structure for the last financial year, that is 1st of April 2024 till the date 31st March 2025. So there is need to file the revision. So this is the complete, you can say, effect of the registration of the scheme. I have talked about the stamp duty, I have talked about the increase in authorized capital, paid up capital, and the income tax point of view as well. Moving on, next slide. Ritika, move on. This is also a effect of registration of a scheme, clubbing of authorized capital, which is already discussed, payment of stamp duty, immovable property. If the immovable property is there in the transfer company, then you need to pay stamp duty according to state stamp act, and for transferring the title, because the property, immovable property, cannot be transferred by possession. And issuance of shares, if the issuance of shares happen in the physical mode. Otherwise, if the demat form, then the NSDL or CDSL will take you accordingly, will get the arranged payment done on the corporate action. And other thing is that if your order is not been the journal order, it being the conditional order, then you need to fill that condition as well for completing the effect of scheme of the merger. Moving on further, this is talks about challenges in fast track merger. One of the major point everybody is not, because the amendment rules is there, the scope has been widened, but yet not notified. So if I'm talking about from the right now eligibility, it is only 3 classes available. So we can say the limited eligibility is allowed, because sometimes what happen in NCLT, you feel that, for example, on the average basis between the two dates, you will take 1.5 months. For example, if my date in NCLT listed in the month of April, you will going to expect your next date in the month of May in between. So basically there is a 30-40 days delay. And sometime matter, for example, in the cause list, your matter listed, I mean to say your item number would be in the last. Sometime bench is not have the enough time to take all the matter. In that case, you are just taking the date but not effective date, because your matter not get heard. So that's why we talks about we generally incline that small merger in which there is no high value involved, there is a no high technicality involved, it should be governed by the RD as well only. Why we are wasting the time of the court will not go in the intricacy, because there is a journal transfer of assets, journal transfer of liability, there is a no for example, listed stock exchange approval required. There is a no requirement to have the scrutiny of the scheme. Journal scheme is there. So we feel deprive that. So for example, there is an average case, two companies is there, but due to they are not small company, they are not the wholly owned or holding company, and they are not other startup company, then they need to go the NCLT. And that's why we feel the limited eligibility till the moment is allowed. Once the draft rule get implemented, I must say that two bigger number of mergers will be coming in the fast track route. One is related to that if my company is not having any borrowing above the 50 crore or below 50 crore, then for example, if my company has both the company having a 40 crore, I can say even the public company, then I can go for the fast track merger. For example, I have the one parent company in India, and who is going to merge its subsidiary into each other. For example, Miss A Limited, B Limited having a common holding company X Limited, and now AB wants that the merger should be done through the fast track, then they can avail. So this is the uh, simply easiness for the company which are not rightly eligible. So we can rightly know say that this is the limited eligibility, not the exhaustive one. Other one is the challenges is regulatory approval. Sometime every practicing company secretary or the professional or the stakeholder, all the stakeholder dealing into M&A knows that the regulatory sometimes take the time much more, even from the NCLT point of view, because sometimes they give a general reason that there is a n number of files pending in the office. You need to wait. So regulatory hurdle is there. For example, I'm telling one more practical example. For example, in my recent NCLT merger case, for the last on the second motion, on the last two hearing, income tax council is not presenting. The bench is asking about the income tax report, income tax comments. We have served everything. Now on the moment when our order is going to be reserved, they say they present, and they say that my lord, I need a time, we need a time to analyze the things. Now I get privilege that the bench could turn around in my favor and claim that we have given the ample time to you. We will no more allowed to you further date, and we are pronouncing the order. So that's why the tribunal will empower it. Tribunal will never say there is a pendency of huge number of cases. Now you will take another date. In the regulatory approval, generally we will face these kind of challenges that sometime it will not work, sometime the matter get delayed. Other one, the creditor objection. You know that the lesser approval required in the NCLT. In the fast track merger, you need to have class wise approval. One thing. The second thing is that then you need to 90%. 90% approval is not required in the NCLT. The other thing is the valuation issues. Valuation issues sometimes arise on the technicality, but to avoid it, you can say you can use a holding and wholly owned subsidiary criteria. If it is not able to use it, then there is a sometime arises for the valuation technologies. Other thing is the accounting differences. Sometimes the financial presentation as per the accounting standards or certain other thing is not aligned between the companies. So you know that the in the regulatory, if your things are not on the structured format, which is generally they seen, they will not going to approve it. In the NCLT, you have the liberty that if any difference is there, you need to technically convince the court. If the merit is there, then tribunal will pass straight away. They will never say that I am not going to approve it. This is the technical see. Other thing is compliance risk. Compliance risk you can talk about in the NCLT. It's been seen that even though the RD has raised some objection, and if you have replied it, even though RD has not satisfied from your reply, though may NCLT approve on the merits. But what happened? There is a some you can say there is a conflict of interest in my point of view. For example, RD, ROC, and the OL all are the authorized bodies of the central government. So generally, once the ROC raises a question, in average cases, RD will not convince from your side. It will support their offices as well, because the modus operandi are the same throughout the regional director, or you can say the ROC or the OL, because the mandate is coming from the MCA. And if we talk about the NCLT point of view, the court knows that if we are not going to allow it, then they will challenge in the NCLAT. If it NCLAT not come in our favor, then we go to Supreme Court. So court will act differently. They will not think about from the executive body from point of view. So that's the challenges, you can say compliance risk. There is a interpretation risk. There is some other gray area. And one more, the average point shareholder disagreement, you can understand 90% is required. So if one person have the liberty, for example holding 90%, other minority shareholder not, so this disagreement lead sometime. For example, 90% is not achievable, then you cannot approve the scheme under the fast track. In the NCLT, lesser percentage is required. So you can, even in the NCLT, you can have the participation court direction on that moment as well. Solvency criteria, in my point of view, in the fast track merger, the biggest hurdle is solvency criteria. If even I have provided my comments in the month of April, then when the rule published should include the solvency criteria much more broader for the holding and wholly owned subsidiary case. In my opinion, if the wholly owned subsidiary is suffering from losses, it should be allowed in the fast track merger, because ultimately parent will, for example in holding company, there is a sufficient funds there in the balance sheet. Holding company will give the undertaking that I am liable even post merger all the losses, all the liability of the transfer company, that is the wholly owned subsidiary, will be merged in the holding company. The holding company straight away say that I will satisfy any liability arises in the within the 1 year or before that, because ultimate parent, I am the parent company is the ultimate owner of the wholly owned subsidiary company. So in my recommendation, it's just being recommendation, because solvency criteria has not been reviewed for any class. If you're, for example, now the April rules get implemented, even though for all class 6 7 class need to satisfy the solvency criteria. And in merger, traditionally we have already discussed, in the curriculum that the merger happen for taking the benefit of one company having profits, another company having accumulated losses, and that company will take the benefit of losses setting off through the profits. In the fast track merger, it is not a, because generally in my technical interpretation, if the losses are there, your net worth will not come into positive way. So that's where the solvency criteria, or you can say solvency certificate, become the biggest hurdle in the fast track merger. So these all are the challenges in the fast track merger. Moving to next slide. These are the know about the forms to be involved in the fast track merger. On the first moment, we can start away with the filing of first form, that is the GNL2 for CA9, CA10 along with CA9. And the other form, for example, CA9, CA10, it's being the physical form. They are to be submitted either through physical or through the e-form. So all are the forms going to be involved in this merger. Like GNN1 required to be filed on the post class approval, creditors and the shareholder with the ROC. And other forms is MGT14. Everybody knows about it. It is not so new form. Physical form is CA11, which is the chairman report about the approval of class meeting. CA12, it's not related with us. It's been the approval order, you can say. CA13 can be used by only the honorable RD only. INC28 is being E form. It's been general rule. INC28 required for the court order or the authority orders. And the GNL2 I have already discussed for the declaration of solvency to be required. These all are the physical as well as E form. And one form is not, I think there, that is the RD1 also there, because RD1 is crucial form for the shareholder approval to be filed with the regional director, that is the central government. Moving on the next, I think the some form, this is related to the jurisdiction, because the ultimate authority is the regional director, and the other involving authority is being related to the ROC and OL. So for example, if we are going to have a merger for the UP company with the Delhi company, then you have a benefit of office of regional directors located in the Delhi vicinity only. And for example, some other states mentioned in this slide covered by the northern region only. So ROC may be different. For example, Haryana, Delhi, the ROC is being same. OL may be different. Chandigarh for the Haryana, and for Delhi, the Delhi OL. For the UP, Kanpur ROC required. OL should to be included in Allahabad. So these all are the jurisdiction issues, and I'm hoping that the jurisdiction issue everyone can cater the thing. It is not so new for anyone. Moving on further, this is also related to the state jurisdiction only. So you can go have, it's been general practice that before going to have a merger, or even in the NCLT or even in the fast track merger, you should always ascertain the costs involved, because one point is there. If you going to be involved multiple authorities, for example, two ROC, two OL, you know that I will not go into deeper that, but everybody knows that if the two authorities there, you need to settle up the things differently. If the authority is one is there, your work going to be easy. You need to just explain the things to one authority at a time only. So this is just all about the jurisdiction. Moving on further, this is all we have covered in the slide, that every jurisdiction for the ease of compliance, that the state, ROC, OL, regional director, everything. Now this is the whole slide about the procedural. Now coming on the FAQs on the merger general, I mean, we try to cover the most practical challenges coming rises through the merger, fast track merger, everything. Now the first question is, merger of LLP and companies are allowed. It's been the debatable points. Some judgments allowed it in the NCLT. In the fast track merger, straight away clear criteria. First of all, company should be there, and company should be classified company, not the journal company. So the first question answer is, merger of LLP company are allowed, not allowed. Under the, I must say that in 233 there is no scope for merger of cross act. You can say LLP Act and the Companies Act. Now on the second slide, The second question is, what if the creditor or shareholder do not approve? We have already discussed. For example, if we are able, if the creditor or shareholder not going to approve, even I can say from the NCLT angle as well, then you will not going to have the merger approved from the even the court, honorable court, or elsewhere from the RD as well, honorable regional director as well. Third question is that what is the scheme, when is the scheme considered effective? This is a very technical point. See, effective has been explained as a scheme, and what is explained effective? Effective date is the date when you have filed your scheme with the ROC. ROC has been taken note, registered it, but effective from the appointed date. So it's been, for example, I am taking the example, appointed date is the date on which your book value going to be transferred into transferee company. But from when appointed date get power, for example, everybody knows that generally in practical merger, everybody takes the previous, for example, back date, appointed date. For example, if I'm taking an assignment of merger in the month of July, so generally we kept the merger appointed date 1st of April 2024, and appointed date is being the general date on the appointed date classify as a date on which the monetary value of the asset liability is to be taken in the transfer company balance sheet. So, and the effective date is the effective date. For example, we generally says that this provision is going to be effective. When is going to be effective? When it is get published in the official gazette. Similar in line, effective means when you have filed the order with the ROC and ROC has registered it, on that moment you get the power to transfer the balances from the balance sheet of the transfer company into a transferee company. So this is being the relevance of effectiveness, effective definition. So this is the question: when is the scheme considered effective? When you are going to file the INC 28 with the ROC and ROC taken the note of the same, getting it registered. The fourth question is all about the are accounting and tax impact considered in? Yes, it's been clearly allowed, but the condition to be met. For example, I am saying no single shares, no single cash is allowed to be paid in lieu of consideration to the shareholder of transfer company. You need to satisfy the provision of merger of income tax. That's why it's been recommended to include the all the condition of income tax act in your scheme straight away. Through that, you will get the power that your fast track merger will get recognition under the income tax act as well. And if we're talking about the accounting standards, yes, accounting standards also require applicability in the fast track merger, because because auditor of the company required to give the certificate for both of the company that the whether the accounting standard followed by accounting principle followed by transferee are same or following the same pattern. If it is indifferent, why it is different, and how the transferee company will take the effect on that basis. So this is the question 4. Moving on further. Question 5. Is the stamp duty applicable on fast track merger? This is very general question, but I already enumerated. Stamp duty include 3-4 things separately: stamp duty on authorized capital, stamp duty on paid up share certificate, stamp duty on immovable property. Do not get confused. Stamp duty in German. Stamp duty applicable on event basis. For example, if you, for example, in one of the fast track merger, we are very privileged to feel that, for example, if we are doing the merger of holding company and wholly owned subsidiary, and generally all are the talks about that if you are going to merge the company, you need to increase in your authorized capital of, and for example, transfer company have the 1 lakh capital for 1 lakh, and my another transferee company having a 1 lakh. So even if the holding or wholly owned subsidiary is involved, no share allotment is required, though the increase in authorized capital required and authority is being asked. And we from the comments of our management, in my case, transfer company have a certain more capital, and that's why my management is not hesitate to pay the stamp duty, because they have the point that if the shares are not issued, why I am increasing my authorized capital. So straight away we have taken the valid point, we have examined the things. In my interpretation, there is a no mandatory applicability under the 233 that you need to increase. And question has been raised in the final stage. explanation has been asked, and we have straight away mentioned if we are not going to allot any single share, then there is no point of issue of clubbing of authorized capital or anything else. So we straight away replied, we have explained everything, and we were very privileged on that moment that we have get the order by not having increase in authorized capital. So this is the intricacy of stamp duty, you can say. So that's why the interpretation, going through the provision bear at very relevant in our cases, because companies that is very lucid, very straightforward. If you have the command over the interpretation, you can convince the authority. Though summing up my conclusion, stamp duty include 3 to 4 separate points. Do not get confused that stamp duty for in generality. Now, if I'm talking about question 6, solvency, a mandatory requirement, which if I think I have already discussed in comprehensive basis. Solvency always be there. Even if you are in discussion, I always ask 2 questions. One is class specified companies, whether they are meeting the criteria. Other one, I'm straight away when I'm going through the balance sheet. For example, some client saying that why do you need a straight away balance sheet? First of all, we have a journal discussion, or straight away say I need to match one more criteria to go through the fast track merger. So this is all about the solvency certificate. Appointed date can be a future date. See, as per the MCS circular and the provision of that, there is a no fixing line. Appointed date can be back date or future date, but for the future date you can kept it in your scheme, but authority will ask the explanation. Why are you giving the future date? Is there any event related to it? Are there any sufficient explanation? If you ready to explain the things, you have the right to, you can put a future date. And what do you mean by the future date? If for example I am standing in the month of July and I have the board meeting, for example, if I kept the date 1st of August, it is counted as future date. Future date means before board meeting, I have the date. And my personal recommendation is there: do not have a future, do not have a appointed date in between. Sometime you are going to see the scheme having the appointed date in between 1st of September and etc. Always have from the 1st April, because in the accounting intricacy you will face the technicality. Always have from the starting of the year, so that you can have a opening balance getting to merge into other things. Otherwise you will have to prepare 6 months accounts, later on 6 months revised accounts. That's the you will face the challenges for having a appointed date. And answer is yes, appointed date can be a future date. Now coming on the next slide, can two company incorporated company? Acha. Yes, the answer, the question is being related, the whether one company is situated in the Delhi, other company is situated in the Bangalore, can they merge? Can they file the petition under the RD? Yes. The jurisdiction of regional director lie for the transferee company, and the absolute power lie in the state in which the transferee company is situated. And other than that, the two states have involved, then ROC will be involved for that state, OL will be involved for that state, income tax also involved. So yes, from different states you can do the fast track merger, but there is some time, there is a cost will be involved in that case. What happened to the licenses, contracts, and registration? See, you need to understand your scheme become the instrument. In the Stamp Act, you are going to read the language as the instrument. What is instrument? Instrument is the thing through which you got the power to take the certain things. It's a vehicle. And in the future, nobody will see the incidental paper attached to the scheme. Everybody read the content of the scheme. So what all the content mentioned in the scheme will be going to be read. So for example, licenses, contract, registration, whatever it being the non-monetary matter, so straight away by the power of scheme you will get transfer. Or for example, in certain licensing it will not get automatically transfer. You need to file application with the order, with the copy of the scheme, with the letters explaining the things. This is the merger approved under the authority. So all, and for example, there is a two thing. One is related to the other authority. For example, provident fund, labor licenses, and other factory licenses, and sector specific licenses. So in there you need to file the letters through the complete set. So yes, and other things related to your private stakeholder in which authority is not available, in a straight away you need to file the letter along with the copy of scheme. The straight away amend the name of the company and will put the transferee company name in the contracts and everything. And what about the regional director can reject a fast track scheme? Yes, the power is like absolutely in their hand. There is a 2 point. On the 1 point, they can recommend it. Another point, they can reject. But for the rejection purpose, for example, now you do not have an solvency certificate, so they can. You can say you can insist to the authority. You can refer back to the NCLT. But sometime on the practical basis, they say you straight away withdraw the application, straight away go to the NCLT voluntarily. Why you are wasting our time to go formally to pronounce the thing, need to explain? So you need to settle the things accordingly. So I can say technically no, ID will not reject. ID either give the recommendation withdrawing it, that you are not eligible to enough, or if you're not persisting or you're not agree to the point, then ID will transfer the matter to the NCLT. Rejection is nowhere mentioned in the act. And the question 10, RD, same question. Now, this is the all about the FAQs, which we try to cover. But apart from it, you know that the fast track merger is much more requirement from the practical experience. 6 months period is being sufficient period if you are able to enough convince the authority. Proactive approach is there. And generally from my past experience, NCLT will take 1 year at least. Even you can do, for example, from the technical point of view, for example, in NCLT generally it's been the line that 2 hearing required for the first motion, 3 hearing required for the second motion, and 6 hearing, and average in between time is 1.5 months. So you can think about 7 months. You can add the listing, because when you're going to file the application the NCLT, you always, there is some chances that you will get the objection from the registry. You need to figure it out. And apart from it, there is a one more example, that even for example your matter get reserved in the hearing, you give the submission, bench has been approved your scheme. For the pronouncement as well, there is a court procedure for pronouncement. The matter should need to be again listed in the hearing, and it will take time. So you can tally from any, even from the across the HNI, from the, for example, majority vast listed company, NCLT merger take minimum 1 year at least. And with that technical intricacy of the court craft, because in the authority somewhere you can become the informal with the, if you have the that confidence. But in the court will require everything, every affidavit required, even one affidavit, 2 affidavit, 3 affidavit, the court will require in their own scenario. That's why everybody feels if there is a no such high values involved, there is a no such high technicality involved, then why will waste the time of the court NCLT, because they have the other some important task to adjudicate the IBC matter. That's why the stakeholder authority, everybody needs the fast track merger should be there, so that executive authority can even utilize their time, and they have the access the data already in their hands. So that's why fast track merger is being win for both of the stakeholder, on the regulatory side, on the court side, and be it on the private stakeholders side, being professional and other things. So this is all about the fast track merger. Now we can start with the.
Thank you, Varun. It was being a, I will say, a marathon session altogether, right?
Might be
Uh,
I'm get bored by the participants,
no,
some
no,
technical staff,
I
but I'm
believe the
trying my best to cover the
participants.
practical things. Yes, you can continue.
Exactly. The participants who have been looking forward to this fast track merger assignments or who are involved in it, they must have definitely had a many key takeaways from today's session, right? And still, as you said, we have discussed few of the FAQs, so we are running out of time. So I will quickly jumping to few of the other FAQs which has been posted by the participants, and after that we'll be concluding the session because I know the time is precious and already the participants have given their valuable time to us. So quickly coming to one question which is asked by Mr. Archit, that is, what is the effective date of the scheme? Effective date can be future date, as you have discussed. Yes, it can be.
Effective, I'm
If you want
again
to,
explaining. I'm explaining effective date is not any date. Effective date generally defined in the scheme as being the date on which we file the certified copy of the order with the registrar. Appointed date is the specific date, which can be future or back date.
sure.
Yes.
So I'm jumping to next question quickly. When stamp duty is applicable?
Stamp duty, I'm already enumerated. Stamp duty has been 4 part. First, stamp duty came on INC 28 on if there is an increase in authorized capital. Another one come on the share certificate. When you have allowed the share, you will issue the physical share certificate. Against everybody knows how the stamping done. This is the second concept. Third one is the immovable property. So you need to check whether your fixed tangible assets containing the land and immovable property. If it is there, then you need to again go to the authority, take the appointment, and you need to pay the stamp duty on the immovable property. These are the three things.
Sure. Coming to next question, for how many years is the transferee company required to maintain the register?
See, for generally the register and everything required by the OL and only for the transfer company. And it is being from the past practice, last 5 years is being sufficient.
Okay.
More than that is not been taken by any authority. Last 5 years is the answer.
Yes, the question asked that throw some light on objective of fast track merger, which you have already given a detailed insight on it. What is the post-merger compliances?
Post-merger already discussed the start from the INC 28 as well. Now the INC 28 get registered with the authority. You have increased your authorized capital. Later on, you will increase the your paid up capital. And once you do the compliance from the Compliance Act point, now you will do the income tax filing. I have already enumerated that you need to transfer a company or successor company need to file revised return in the GST as well. Same, you need to take the input balances, or again from the non-monetary point of view, need to take the immovable property title deed, you need to take the licenses, you need to amend the contract or need to annex the annexer. So these are the step phase manner. First, you will take the accounting balances, balance sheet balances, and once you transfer it, you will again go for the non-monetary matter like licenses, licenses, vendor agreements. These are the two parts.
Now, can MSME go for fast track merger?
Yes, MSME falling. MSME is not defined in the fast track merger. Small company criteria is there. If your MSME company falling under the small criteria or holding wholly owned subsidiary company or startup recognized, then you have the enabling clause for the fast track merger.
Okay. Is approval from income tax department also required during this process of fast track merger?
Yes, I have already enumerated. You need to serve the copy of whole petition to the income tax and generally approval through the questionnaire. All authority except even RD will send you the 40-pointer, 30-pointer questionnaire. You need to answer it. Once you provide everything, they will give you the green approval.
Okay. Now, next question: investigation of company is pending under any ROC. Then also that company can go for fast track merger?
No, in that case, ROC straight away first of all issue the notice in the first motion itself that your company is under investigation. First complete your investigation satisfied, because what happen if merger happen, your company might be get shifted, all balances shifted to the transferee also come into picture of investigation, then the ROC will again need to excise the things. So if anything is being there, then you need to satisfy the things. First of all, complete the investigation. Even in the NCLT as well. I'm sharing one more insight from the NCLT. NCLT bench always ask about the affidavit from transferee. There is no inspection investigation pending under the Companies Act.
Right. Next question: wholly owned subsidiary is not the solvent company due to loan from holding company, and both the companies are planning for the fast track merger. In this case, said loan of the holding company will be merged or set off after the merger take place. In this case, solvency is still required.
Yes.
Because lastly, the said loan will get it merger with the holding company only.
Same from practical experience, as per Act, there is no exemption allowed for the insolvent company. I am already discussed the case that my point, if the subsidiary or holding merger is involved, then there is no criteria of solvency. Solvency should be seen from the one point, consolidated basis. But on the moment, there is no criteria allowed if both company, because you need to give CA10. If your net worth is not coming into positive, then how your auditor will say that this is company is solvent? Or CA10 has been the must requirement on the first stage. So you will not go to allowed to move on further for the class approval.
Okay. Next question is: for 4 companies want to merge into another company. Yes. Out of 4 companies, 2 are small company and other are holding and subsidiary. Can merger be done through fast track merger?
So you need to understand, for example, 3 criteria is there. For example, if we talk about the small and the startup, they are allowed intermingling For example, 4 companies are there. Four of them I have to certify either they are the startup recognized, either they have the small company definition. For example, 2 of them is small, 2 of them is startup allowed. If you say that holding and wholly owned subsidiary criteria is being using, then in that case, 1 company is holding, 3 companies should be wholly owned subsidiary. Then it is.
Okay. Okay, but like this, like two small companies and two are holding a subsidiary, that won't be allowed, right?
No.
Okay,
I
okay,
must say I'm recommending if you consider the option wholly owned subsidiary and holding, then do not get merged with the small and the startup. You can merge, for
okay,
example, you can use my 3 companies is startup, one is small. You can use it in between, but the second criteria, holding and wholly subsidiary, will not be get included because the criteria is there holding and n number of wholly owned subsidiary company
okay, okay.
or vice
Uh,
versa.
com okay, coming to the last question, what are the consequences if transactions are flowing in merged company accounts?
What is the? Can you come again?
Yeah, what are the consequences if transactions are flowing in merged company accounts?
I'm not getting the point because I'm already
Uh,
telling.
can I take the
Yeah, I'll get
opportunity
it.
to explain
Yeah,
the
please,
question?
please, please, I'll
Sorry.
get it.
Hi, Varunji. So
Yes.
basically, I am looking into more of a transactional side of a merger. So basically, we are providing automated solutions, right?
Right.
So in that, after the merger happens, after it has been approved by NCLT, the transactions are still flowing into the company's account. They give a period of 25 days from the order date to close all the bank accounts, and no other fund should flow into the bank account, or the accounting entry should flow, right?
Right.
But let's say something or other leads to a delay of this. Then I would like to understand what are the consequences.
See, there is a. I think you are talking about from the time limit. How much time limit is being granted for the completing the merger effect? I'm right or
Yes.
not?
Yeah,
See,
yes, you're right.
in the NCLT, there is a provision of filing of a statement within the 9 months. If you are not, for example, I am comparing the NCLT with the fast track because you will get the hint from that angle. In the merger, in the NCLT as well in the fast track, there is a no time limit mentioned in the order in the provision that you need to complete the merger effect or merger conditions within that time period only.
I'm really sorry. I missed mentioning it. This is not related to a fast track one. That's why.
Okay,
Sorry about that.
it's been related to your NCLT.
Yes, it is NCLT approval.
Even I can explain the things. Even in the NCLT, there is a provision that if, for example, your merger orders came in the 1st July, you have filed the INC 28. Now you are taking the effect of your accounting balances, everything, whatever required.
Hmm.
And now on the 31st March 2026, you need to prepare a statement scheme wise. What are already being completed? What are the pendencies is there? And for that, you need to file the with the ROC.
I
It
don't
is.
know, but there is some problem because we are doing it for someone, and we are facing a lot of challenges. The issue is Ketan companies are involved. They are leading the
KCO.
merger.
KCO. Okay.
Okay, okay, and we are just supporting into the automation process where the funds will, where the transaction will cease to happen in the company which is getting merged, and the acquiring company will have all the intake of the transaction. Any fund flow that will happen over there. Any invoices that are being raised will happen over there. But there is a time gap that we have a feeling that we might miss. We have been told that this needs to be closed within 25 days from the order of NCLT.
See. This being the interpretation issue, if I am going through 230, 232, if, for example, I have privilege to have one of the NCLT merger in the month of this month or as well, and it's being the first merger, and I am going through the intricacy post merger as well. As per the provision, as per practical insight, there is only one condition that the 30 days allowed for filing the order copy with the ROC.
Mhm.
Apart from it, there is no such condition in the NCLT order. There is no such condition precedent allowed in the provision of the Companies Act. You have to declare on the closure of the year what are the compliances you have made through the scheme, what are still pending. For example, next year, 31st March 2027, still you are not able to complete the effect. For example, you say zero need to be done, then again you need to file the statement. The provision talks about you will file the statement on year basis. Once, for
Okay.
example, for you say 2026 on the March 31st, you say that my all things get completed. Zero is being outstanding. Now again, first statement is required for the next year. Later on, you will not supposed to file another statement of pendencies. But there is, in my, might be I'm get wrong, but if there is a provision containing, there is any
No,
judgment
I
containing.
understand, and I think let's connect offline on this, and so that I can share more
Yeah, yeah,
details
yeah.
with you. So that will be better,
We will
right?
have
But
a
yeah,
discussion with
definitely.
Mr. Abhinavji
No,
and
no,
myself, and
definitely. I'll be
Yeah.
sharing the contact details of Mr. Varun. So any other question left will definitely can be taken with him or can be passed on to us. We can
or even
cross check with him and can share with you.
yes, yes, sure, sure. Even we
Yeah.
can receive the email as well post that if
Yes.
anybody
Yes.
has
Yes.
the query.
Sure. Sure. Just a last question, because we are just running short of time. For how many years valuation report need to be prepared? I believe.
Years is being not there.
Yes. Yes.
Evaluation report means the valuation report as per the RVO rules. It's been nothing mentioned in the 20 because what valuation happen? Valuation will take, for example, DCF is being taken, net worth technology is being there. The balances as a movement is being required.
Right. 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 So, Varunji, really thank you. I believe we had taken all of the questions. There's still few left. We'll be coming back again with the same terminology. We'll be coming back with the written FAQs shortly on your mails. And again, I request now CS Akash Agrawal ji to share a vote of thanks for the today's session because again, I said we are running short of time. So we need to close this complete marathon session, I will say, quickly. And thank you again for sharing your insight. Akash ji, over to you.
Yeah, good evening, everyone. This is CS Akash Agarwal. This is my honor to deliver the vote of thanks to on behalf of our organized team. First and foremost, a heartful thanks to our esteemed speaker, CS Varun Agarwal,
Thank
for
you.
sharing such insightful thought on knowledge on topic of fast track merger. Their expertise and clarity have certainly enriched us all. And Mr. Abhinav Agarwal, please present vote of appreciation.
Yeah, definitely. As a
Yeah.
gesture of, you can say, appreciation, we will just bestow you with one certificate of appreciation. Right. I will request Ritika to please place it, share it with everyone.
Thank you. Thank you. Always having a privilege to discussion like this. I'm not saying I'm the speaker. I'm saying that I'm getting the experience.
Yeah.
So this is from our side. And yes,
Thank
Varunji,
you.
as you rightly said, as a company secretary,
Yeah, I would
right?
also
That
like to
yeah.
thank our participants for their active involvement and thoughtful questions and continued support throughout this webinar.
Thank you, Akash ji. Just to sum it up,
Yeah,
Varunji,
thank
as you
you.
rightly
Have a
said,
great day.
yeah, as you rightly said that yes, once this notification will be notified, then the immense opportunity will be coming for the company secretaries in this domain, right? It's depend on us how much prepared we are, how much ready we are, right? So I request all my corporate governance warriors, I always say,
Sorry to disturb you once. One more question that I am recommending to all the practicing company secretary, though the comments time being over, but you can recommend it to the ministry email that the solvency criteria should be removed in some cases or
yes,
should give us some relaxation.
yes,
Otherwise, it
yes,
will not give the multi-facet benefit to any
right,
companies involved in
right.
this merger.
Right, right. Absolutely, absolutely. So I believe it's a good opportunity for us that we can encash on it. We can start introspecting on this fast track merger norms so that once this notification will be there in the pipeline, it will get effective. Definitely, we can suggest our clients and our companies to go for it, and it will be a very cost effective process. And as an opportunity, yes, we as a company secretary will surely evolve and grow. So thank you everyone for joining, for motivating us, for encouraging us to keep conducting such kind of webinars. Yes, last week we did on FLA, this week we did on fast tech merger, and definitely we are coming with some hot topic on next week on Friday or Thursday. And looking forward to your support, motivation, and encouragement in coming days to come, in coming weeks to come, to conduct these kind of webinars. So thank you everyone. Thank you Varunji for sparing your
Thank you,
time.
Abhinavji. Thank you, Akash.
And
And thank you
Thank
to
you.
all
Thank
of
you. Thank you,
you
Varun.
who
Thank
listening
you.
to me for
yes,
last 2 hours.
it has been a fantabulous session. Trust me, I have been witnessing and hearing many of the webinars and sessions, but the marathon session you have run is really, you have shared all your practical insight and experience. So thank
Thank
you,
you for your
everyone.
kind words.
And yes, we'll be sharing the link of this webinar. It will be uploaded on the YouTube along with all the written FAQs and the PPT for all your reference. And yes, keep growing, keep learning, keep exploring.
Thank you,
Thank you
everyone.
everyone. Thank you.
Thanks.
Thank you.